Hello and welcome back to EduRev. Today we have some exciting news to share with you. First of all, let's discuss why this topic is in news. Recently, the Supreme Court, SC, has rejected a sealed cover suggestion from the government pertaining to the Adani Hindenburg issue. Do you know what is sealed cover jurisprudence? It's a fascinating legal concept that allows sensitive or confidential information to be presented in a sealed envelope to be opened and reviewed only by the judge or judges in charge of the case. This practice is derived from Rule 7 of Order 13 of the Supreme Court Rules 2013 and Section 123 of the Indian Evidence Act of 1872. This can be used in situations where the information is related to an ongoing investigation or contains personal or confidential information that could result in a violation of privacy or breach of trust if disclosed. So, if you're interested to learn more about sealed cover jurisprudence, keep watching. Now, let's discuss about what are the issues related to sealed cover jurisprudence. Lack of transparency. Sealed cover jurisprudence can limit transparency and accountability in the legal process, as the evidence or arguments presented in the sealed cover are not available to the public or other parties. Disparate access. The use of sealed cover jurisprudence can create an unequal playing field, as the parties who have access to the information in the sealed cover may have an advantage over those who do not. Limited opportunity to respond. The parties who are not privy to the information in the sealed cover may not have the opportunity to respond to or challenge the evidence or arguments presented in it, which can undermine their ability to present their case effectively. Risk of abuse. Sealed cover jurisprudence can be abused by parties who seek to conceal information that is not legitimately confidential, or who use it to gain an unfair advantage in the legal process. Interference with fair trial. The use of sealed cover jurisprudence can interfere with the right to a fair trial, as the parties may not have access to all the relevant evidence or arguments that are considered in the decision-making process. Arbitrary nature. Sealed covers are dependent on individual judges looking to substantiate a point in a particular case rather than common practice. This makes the practice ad hoc and arbitrary. Now, let's have a look at some of the Supreme Court cases related to this. One such case is P. Gopalakrishnan versus the State of Kerala case in 2019. In this case, SC held that disclosure of documents to the accused is constitutionally mandated, even if the investigation is ongoing and documents may lead to a breakthrough in the investigation. After knowing all the important information related to the topic, now we should know what can be the way forward. The use of sealed cover jurisprudence must be carefully balanced with the principles of due process, fair trial, and open justice, and be justified and proportionate to the specific circumstances of the case. Courts and tribunals should also ensure that the parties who are not privy to the information in the sealed cover are given a fair opportunity to present their case and challenge the evidence or arguments presented in it. Thanks for watching. You can study more such amazing news in the current affairs course on EduRev.